absurd, really, in terms of the cases involving the former and the current president and family and so forth. So it's a crazy time to be a lawyer, I think. But I thought we would cover the following topics. One of them is really just an update, so maybe we'll do that first. So the topics are the Fannie Willis Nathan Wade disqualification scenario, order from the judge, and subsequent events. Then the Florida case against the former president, Donald Trump, and whether or not the trial judge there is going to do something with a selective prosecution theory. And as a part of that, you guys, I thought we might talk about the case from California where a federal judge recently dismissed an indictment on selective prosecution grounds. And then also, I thought we would discuss the special prosecutor who was tasked with investigating the current president's alleged mishandling of classified information, his testimony and report. We haven't talked about that, I don't think, have we, you guys? The report came out a while ago and the testimony was last week, but I don't think we've talked about it much at all, have we, on Spaces?
We have not.
Yeah. Okay. So I thought we'd talk about that a bit. And then the last one is just a little short one, so I may turn to that first, but it's basically what's going on with Hunter Biden's gun case in Delaware. So is that enough of an agenda, do we think?
It sounds like an 8-hour session to me.
Yeah, that's a mouthful.
It's a handful, but okay. Well, if it's going on too long, then we'll break and we'll pick it up another night. And different people, let me say this too, various people have at times asked us to comment on the Alvin Bragg prosecution. And I was thinking we might do that next week, but now they've continued that case for at least another month, right? So, but I do think we haven't given much love to that case. I do think we should probably do one session just on that. And then I already have said that we will do one on the Fisher case that's currently pending in the Supreme Court about whether this federal statute 18 U.S.C. 1512 is properly applied in the J6 scenario. So I think, you guys tell me if you disagree, but I think those two are better as standalones. Is that all right with you guys?
Yes.
I don't know anything about either one.
Right. We'll have to bone up on. You don't know anything about Fisher. Come on. That's not true. Yeah, so we'll have to bone up on those. Okay, so people are still starting to filter in, but let me go ahead and get started. So let me do the quick one first. So did you guys notice this there was looked like a telephonic status conference with the judge in Delaware on Hunter Biden's gun charge. Did either of you happen to listen in on that? King, did you have time? I know you're interested in that case. Yeah. Yeah. Okay. So the docket, she put on the docket that she's going to conduct the jury trial on that gun charge June 3rd, the week of June 3rd. And basically, she says the docket entry says it's going to go for as long as it goes. Here, the judges typically you can tell me what the practice is on the West Coast, but here the judges typically set like a specific number of days, at least initially for the trial. Like they'll say it's a 5-day trial or it's a 10-day trial and we're not going to sit on Fridays or whatever. But her order seems kind of open-ended. That would be a little unusual for here, but maybe it's not other places in the country. What do you think?
I think for a relatively short trial, in general, I think judges generally are looking at whether it's going to be 1 week or into a second week.
Right.
Because if they think whether it's a 2-day trial or a 4-day trial doesn't really make much difference to the judge's scheduling of their own calendar. It wipes out the entire week.
Or what they need to tell jurors, right? So that's kind of how I interpreted it too, that it's like at most a 1-week trial.
Right, and that, given the nature of the case, that's what I would expect. This is a prototypical 6 or 7 witness, and that's it. Government will be done in 2 days.
Right. In the EDVA, that's a 1-day trial, and the jury convicts you before 5:30. So, okay. All right. King, have you got any comments on that?
Nope.
Okay. All right. So, shall we? What do we want to talk about first? Do you want to launch into the Fannie Willis disqualification
If yeah,
imbroglio?
if you pick me, I warn you, I could talk for a while.
Okay. Well, do we want to cover the media has done, on both sides, good and bad, coverage of this thing that this judge did. So if we start high level, we can cover a lot more stuff, but um, I'm just wondering if maybe we just want to pick specific aspects of it or points of it and debate those rather than like telling people and here's what happened and they've already read it 3 articles on Town Hall and Red State and so forth about it. So King, have you got a view?
I'll start.
Okay, go ahead.
Yeah, what happened was the judge split the baby in Solomonic fashion. He could have disqualified Fannie and her former boyfriend uh, based on, at, at a minimum, an appearance of a conflict or appearance of impropriety. Instead, he picked the boyfriend only, gave Fannie Willis the choice: either you get off the case or he gets off the case. Well, which everybody knows how that goes.
You didn't expect her to fall on her sword, did you? Oh.
So, and basically, that's
At the
how it
highest
went.
level, that's what happened,
On a
right?
high level, that's what
Yeah.
happened.
Well, that's what we
On
said
a
was going to happen, wasn't it?
Yeah,
Isn't that what we predicted? He was going
we
to
did.
throw
We
one of
did
them
predict
off
it.
on
Yes.
appearance. Probably not both, but at least one.
Yeah. Uh, there's an interesting phrase in the judge's
Oh
opinion.
yeah, I'm gonna get to that. Okay, so
Okay,
and
well, you
I
tell me.
specific yeah, I told you
Give me a
to
heads up.
yeah, because we definitely want to talk about that, and you were the first to spot that, so I want to give you credit where credit is due. Um, okay, so we this is what we thought it was going to be, right? So people know the judge wrote, I think it's 23 pages opinion explaining this. He explains why he doesn't see that there's an actual conflict, why there is an appearance of impropriety problem, and what he thinks is proportionately, the remedy for that. And he makes several interesting, sort of little specific comments that I want to get you guys' opinion about. But just, I know most Americans are not going to sit down and read that 23 pages, right? So it seemed to me that he did a pretty good job of setting forth what the issues were that he had to decide on for purposes of this motion, right? And he specifically says, look, it's not up to me to figure out if each and every witness who appears in my courtroom in front of me is telling the truth or not. Like, the courts would do nothing but that if that's what we did all day. But and I think that feels unsatisfying to the members of the public who watched the hearing themselves, and then they think, and they're telling me on my Twitter, what do you guys think? They're saying he should do something about the fact that they obviously lied, right? But one of the things I want to try to help people understand is that's kind of not the way motions go in front of a judge. The judges only rule on the arguments and the issues that are presented before them, which isn't to say that a different judge might not have gotten more exercised over some of the conduct that took place in those hearings and commented on it. But really, do we think he could have done anything about the behavior of the participants in that hearing beyond what he did?
But he could have found that both Fannie Willis and Nathan Wade committed perjury. He could
Well,
have.
he could have found that they weren't truthful or that they weren't credible, right? To find they committed perjury, he'd have to lay a charge against them and give them a right to defend themselves.
Okay, well then, all right. He could have found they were not truthful. They
Right.
lied,
He
and
decided he didn't need to do that,
he
right?
decided he didn't want to go that far.
Right.
Uh, uh, although he hinted that that's what he was thinking.
Right. But I want to address this specific point because lay people don't seem to understand this. So he did not say they committed perjury. He was never going to find them guilty of perjury. He could not, on the basis of this motion, even charge or allege them guilty of perjury. So, Ship, can you explain to people very briefly, like, if you're going to deal with perjury, this is a specific criminal offense, right? A judge can't just launch into perjury issues in the middle of any random motion, right?
I'll answer that. He cannot do that as a criminal charge. What he can do is sanction lawyers who lied to the court. He can also refer lawyers to some prosecutor for investigation as to whether they committed a crime. And he also can hold or institute contempt proceedings against lawyers.
Right. But he can't do that in the midst of this motion, right?
No, but he can find in the midst of the motion, I find that the testimony of so and so was not truthful. So
Right.
I'm
He can
going
make
to,
a factual finding or
yes.
a statement of his belief in their credibility. But what people are writing me, they're like, why isn't she charged with perjury? Because that's not how this motion gets resolved.
Plus, the fact of the matter is that judges very rarely make findings that somebody has lied. They may say that they don't credit their testimony, but in terms of putting it in their opinion that they've lied, they don't do that. And particularly where the witness is a high profile individual.
Or an elected official.
So I think that anybody that was expecting that was being unrealistic, and that the judge went about as far as he could have under the circumstances. And he's right, because in terms of the issue in front of him, whether or not they lied doesn't change the motion, which is based on economic conflict of interest. What the defense said, in essence, was, Fannie Willis was getting something, i.e., these various vacation trips that they took, paid for by making Wade the prosecutor in the case. And the judge found that there was certainly that appearance, even though it wasn't all that much money when you boiled it all down. And on that basis, he said that Wade had to get out or she had to get out. But even if he'd found that they both lied in terms of trying to cover up when their affair began, it doesn't change the analysis on that issue.
Right. You remember Judge Sullivan tried to hold somebody kind of spontaneously in contempt. Remember this back in the Flynn
Judge
case?
Flynn, or General Flynn.
Right. He was wanting to hold Flynn in contempt for retracting his plea or going against his plea somehow. And, a judge can't just launch into contempt or perjury proceedings in the middle of another proceeding.
Well, the Supreme Court has said so.
Right.
There's a Supreme Court decision that goes back 150 years that says that.
Right. We filed an
Yes.
amicus brief, our group did, in the Court of Appeals, basically reminding them that, the Sullivan can't do that. So it's unfortunate that sort of the public doesn't understand that this judge couldn't just react to everything that was happening during that hearing and address all of those issues in the midst of this proceeding, because that simply is not how it works. Now, he can, King, as you said, he can refer them to the bar. He kind of came close to doing that without actually doing it. What did you guys make of that?
Well, I want to back up a step. The following sentence, when I read it, it was like, I don't know why he twisted himself into linguistically the way he did to say this. Such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. Yet the testimony withstood direct contradiction was corroborated by other evidence and was not so incredible as to be inherently unbelievable.
Right.
How
I know.
incredible
I
does
had
it
to
have
read
to
that
be to
three
be
times.
inherently unbelievable?
I had to read that 3 times. What is he saying?
I mean, I understand Steve's point, but he's factually saying, I'm not persuaded that Fannie Willis took the stand and gave straight answers to the questions posed to her.
Right.
He said just the opposite. He said, I don't think either side has proven that witness X told the truth or didn't tell the truth. He kind of he said nobody has convinced me uh, on any standard of proof that somebody isn't lying, but they on the other side they haven't convinced me that they are lying. So
He
he
came pretty
basically
close to
waffled.
saying, yeah, he came pretty close to saying Bradley, the former partner lawyer, that he lied. He said he didn't credit him. His
Yeah,
testimony at all.
Bradley he discounted, but the others, the main witnesses, namely Fannie Willis, uh, Miss Yurty, and Nathan Wade, he essentially kind of punted on whether they were telling the truth or not.
But he made clear, I think, if you're an experienced lawyer, you read that and it's clear he didn't believe Willis, he didn't believe Wade.
Right.
But he says it doesn't matter in terms of the issue that's before me. It doesn't matter when their affair started, which is what the line is about. They acknowledged that they had a relationship.
Right.
So they didn't try to hide that. And they acknowledged that they went on these trips together. Now, of course, there was documentary evidence. They couldn't have said otherwise. They may or may not have lied about whether she reimbursed him. But the judge did a good analysis of how much money was at stake. And frankly, the amounts of money were not so stunning that Fannie may not have been able to reimburse that out of cash that she had. I may be dubious personally that she did, but he's right that it wasn't like it was tens of thousands of dollars that she would have had to have lying around in order to reimburse. So he basically says, I'm not going to get into that because it doesn't change the analysis on where I'm going to come out. I thought that was good judging. That's what I would expect a responsible judge to do.
He did also what I've often told people, and they don't like it, which is just because this person lied about whatever it is does not mean the opposite is true. That's not proof that the opposite is true.
It,
And
it, it,
lawyers and judges look at it that way, but of course, regular people don't.
now I quarrel with what Steve said in one respect. There was a second prong to the defense motion, the so-called forensic uh, misconduct.
Which is unfortunately named. Really?
It is. It really is. But included in that, and particularly Jeff Clark's lawyer made this point, that if you have a prosecutor, a senior prosecutor, leading the team, and uh, the sitting DA giving false testimony and suborning perjury, that's disqualifying. Apart from whether or not they have a financial interest in the case, and this judge's opinion walked a thin line between, as Steve said, he believed they lied, but he wasn't going to find it. But that raises the question: what about that other prong, that disqualifying fraud on the court, so to speak, that was alleged?
My response to that, and I acknowledge your point in theory, but my response to that is for a judge to say, I find that you're a liar, Mr. or Ms. Prosecutor, and therefore I'm going to throw this whole prosecution out or disqualify your entire office. We would think that in other circumstances, if the shoe were on the other foot, that to be the height of judicial usurpation of powers that they don't have. You know, whether Fannie Willis, when she started her affair with Nathan Wade, I have my opinion, and I'm clear on that. But and I'm not a fan of this prosecution either. But I will say that from the judge's perspective, that that whatever lying she did and Wade did, and she may have helped to orchestrate about when they started their affair, doesn't change one iota whether she would have charged these defendants in this case. She didn't do it because of her affair. That is completely unrelated to her affair.
Yeah,
I,
it's unsatisfactory
I,
because when you step back and look at it big picture, if you really want to talk about the appearance of justice or the lack thereof, right? The nation sat and watched this whole hearing, which made it seem like there's just no way that these venal people should have this much power over other people's lives. That's what people saw.
Especially a former president of the United States
Right.
well,
and senior officials.
it's actually more than that here in this case. Here you have defendants who are charged with making false statements to legislative bodies and to state officials, and they're charged with crimes for making those false statements. And you have on the record in this case evidence that the prosecutor herself, the lead prosecutor herself, has made similar false statements and has assisted another prosecutor on the case and her former boyfriend in in uh, uh, making not only
Trying to
false
pull the wool
statements to
over the
this court,
eyes.
but
Yeah.
but
Right.
another judge in the divorce case.
Right. Yeah, a different judge, other than Judge McAfee, would have made more out of that, would have expressed more, indignation over it. Um, but you still have to boil it down to, okay, but can you really disqualify the elected prosecutor from her office over that? And a point that I want people to know is prosecutors almost never get thrown off any case. Like 99.9999% of the time, that does not happen. That is why this defendant, was his last name Roman, his lawyer declared victory, getting even Wade disqualified off the case. It's a
Yeah,
major accomplishment for a defense lawyer to do that.
but 99.999% of the time, you don't have the prosecutor take the witness stand and raise their hand and testify under oath.
That's true.
Well,
I
but
did it.
that's a victory in and of itself.
Yeah.
Oh, I agree.
This was a
I agree.
huge win for the defense
Yeah.
because they have completely shifted the narrative.
Yeah.
Instead of talking about what the defendants did, it's now all about what Fannie Willis and Nathan Wade did, and whether
When
they
and
told
where
the
and how
truth,
much it
right?
was and whether they've
Whether they
lied.
told the truth about it. And you've now got in the public discourse this whole issue about she's prosecuting these guys for lying, and look at her.
What a liar she is.
You know,
Right.
so
Yeah.
I've been I've been around criminal law for 50 years now, and I can count on one hand and have fingers left over how many times I've seen a motion like this succeed to the extent this one has.
Well, I agree 100%. This one is stands out as being a unique uh, exception to the general rule. But once it's got this far, uh, I think in my opinion, it takes a strong judge to get this circus part of this case out of it.
Yes.
And I'm
Absolutely.
not sure how you do that other than by getting rid of Miss Willis.
Right. Well, this judge showed no inclination toward tamping down the circus aspect of it while she was on the witness stand, unfortunately.
But he
So
called her out on it.
he called her out in writing. I guess he's not prepared to do that to her face, but he is prepared to say she behaved unprofessionally, which anyone with eyes could see.
But part of this is letting the public see for themselves
Yeah.
what's going on. I had a case I tried once, a murder case by arson, where the defendant was a woman. And throughout the trial, which lasted a week, she came into court in a yellow raincoat with a hood, and she had the hood pulled up over her head. And the judge, who was the best judge I've ever appeared in front of, I asked him after the trial when she was convicted why he hadn't required her to take the hood down, because it was disrespectful to the court. And he said if she wanted to do that and portray herself that way to the jury, I was not going to stand in her way. And I think that what we've got here is the judge doing sort of the same thing. And I want to speak up on behalf of this judge. I don't know him. I have no knowledge of him other than what I've seen of him in this case. But this judge, I think, thus far has impressed me as playing it by the book. And, some of the things he said in this opinion were, in lawyers' terms, pretty tough against his former boss, Ms. Willis. This guy is no Lance Ito. He's not rolling over because she is who she is. And equally, he's not rolling over for the defense in the case. He's saying, all right, you've got a point, but it only takes you so far. So I agree that the case is a circus, but I think all things considered, this guy is doing a pretty good job in terms of being the ringmaster.
Within the narrow confines of what's in front of him, which he says this multiple times in the opinion, he feels constrained by the cases that are decided by the Court of Appeals or what was actually alleged in front of him, as opposed to all the other stuff. So this is something I wanted people to know too, because it was very dissatisfying the way it came out after watching the whole circus. But people need to realize that some of the stuff he says, and now, King, I want to turn to this one uh, particularly piquant remark that the judge made. Some of the stuff that he's written from a lawyer's point of view is pretty jaw dropping. Pretty jaw dropping. So tell us about this little nugget that you picked up on, King. Oh no.
Oh, I had the mic off. Sorry.
Oh, okay. I thought I lost you like we did last
No,
week. Go ahead. Go ahead.
I was looking for my notes. Hold on, let me find my notes. Am I still there?
Yeah, you're here.
Okay. Um, he 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 wrote, however, after describing witnesses' testimony, particularly Bradley and others, he said, however, the odor of mendacity remains. And those three words, odor of mendacity, kind of triggered something in me, and I
Yeah.
Googled, and I was right. Tennessee Williams from Cat on the Hot Tin Roof
Right.
used that very phrase.
All right, so those of you who are not literature majors in college, you still may have heard of Tennessee Williams. He's one of the most celebrated playwrights, American and a Southerner playwrights in the 20th century. He wrote The Glass Menagerie. He wrote A Streetcar Named Desire. He wrote Cat on a Hot Tin Roof. The latter of those were made into movies. And so he's a famous Southern writer. And when you referenced that, I was like, what's this judge's background? Because if he referenced that intentionally, that's amazing. Now, he doesn't put quote marks around it, right? But I went back and looked at Judge McAfee's background, and his college degree is like in political science with a minor in music, I think. Like he looks like a liberal arts major to me. So I asked King whether he thought that happened intentionally or not. It looks to me intentional. What do you think?
I think it's absolutely intentional, and I've got a long explanation as to why.
Okay, go ahead. I'm fascinated to hear this.
It includes a story,
Okay.
a childhood story. I grew up in a small town, 3,500 people, and there was a movie. Lived on one side of the town. School was on the other side of the town, and in the middle was a movie theater. The only movie theater the town had. It would get second run movies, nothing right out. So you could generally wait a couple of years after before it
To see
got
the
there.
latest out upcoming thing.
Right,
Okay.
and so Cat on the Hot Tin Roof was made in 1958.
Yeah.
So by the time it got to my town, I was probably around 12, going on 18,
Ooh, right.
and I that movie theater was on my way to school. I walked past it every day, twice, going and coming. And I remember the week that Hot Tin Roof hit the movie theater because it had a giant poster of Elizabeth Taylor in a white slip, bare
Right,
shoulders,
right.
on it.
And that
And
slip's hugging every curve she's got.
exactly, and there was a still photo, great big life-size still photo of Elizabeth Taylor, also advertising the movie, and it was there for a week. Walked past it, going and coming every day for a week,
Which
and my
must have
parents
blown
wouldn't
your
let me.
12-year-old mind.
And my parents wouldn't let me go because they thought it was about a prostitute.
Which it's not, you guys. She's not a prostitute in that movie.
Yeah. To my surprise, I saw it on TV a few years later on one of these Saturday night at the movie
Yeah,
shows, and it wasn't about a prostitute at all. It
right.
was about a dysfunctional family,
Right,
a very, very dysfunctional family,
right.
and, the theme
A
of it
very
was,
southern dysfunctional
oh,
family.
absolutely, and everybody lied.
Mm-hmm.
Everybody was living a lie and
Right,
telling lies to one another, and that's what it was about, the
right,
lies.
right. It's the theme of the play.
Exactly. And so the quote, the odor of mendacity phrase comes from this bit of dialogue where Big Daddy, he's the owner of the Mississippi Delta plantation, and he's talking to his son Brick, who's a alcoholic and former college football star. He says, "What's that smell in this room? Didn't you notice it, Brick? Didn't you notice a powerful and obnoxious odor of mendacity in this room?" Then he goes, a couple people comment about it. So there ain't nothing more powerful than the odor of mendacity. You can smell it. It smells like death. That's where that judge got that phrase from,
Right. I
that bit
think
of
so
dialogue.
too. And that theme in the play, the point of it is that everyone's lying about who they are in order to uphold what on the surface is the socially correct thing, but isn't really what people want to do underneath. And so I don't know whether this judge intentionally is trying to convey that literary message or he's just subliminally, he's a southerner himself, right? Whether he just subliminally got that message and he that's the right phrase that came to him. But if you like read between the lines and look at it on a deeper level, it's a very apt description of the problem.
Uh, the problem being everybody's lying.
Right. Right. In a situation where this is a public prosecution of a prominent a person, right? And even if he weren't prominent, like the public officials are not supposed to be behaving in this way. So,
And,
yeah.
and and I've got a rant that goes with this. I don't know if you want to hear that now.
Is it a short rant? Because we could do a short rant.
It's not too long. Um, it has to do with mendacity. Um, it has to do with the
Oh, well, but before you say that, because you said the word so many times, Merriam-Webster announced that there was a spike in searches for that word last week. Yeah, because people were trying to understand, and that's because of this judge's opinion. Searches spiked nationwide on mendacity.
Well, and that's the theme of my rant.
Okay.
Um, this criminal case is at its heart a RICO case, in which Fannie charges Trump and other defendants with uh, conspiring to violate the RICO law, which entails associating with an enterprise. The main distinction between RICO and other criminal statutes is the enterprise aspect. You everything you do to commit a crime is done through or by or to benefit some more or less formal organization called an enterprise. Fannie doesn't. This indictment doesn't really define much of an enterprise or uh, allege how the various defendants are associated with it. But it's an enterprise crime. Uh, I've tried them and I've litigated them on both sides, on the civil side, plaintiff and defendant. Uh, so I have a good bit of experience with RICO cases. This is not your typical RICO case. It stretches RICO law. Uh, but the theme of it is that this enterprise was unlawfully used to change the outcome of the election. Um, that's not a crime, changing the outcome of the election. I've handled cases involving election contests, which are
King, wait. She put unlawful in front of it at the
she. All
time.
right, I just put the unlawful, aside for a minute. A,
She put
a,
it. She put it in
Those
there everywhere she needed it.
That's the
Everywhere
new
she needed it,
rule,
she announced
King.
unlawful.
Right. That's the
yeah,
new rule.
which,
If you write unlawful in front
yeah,
of
well,
stuff you're
yeah,
allowed to
that
do, it
makes
makes
it
it a
okay.
crime. Yeah.
But I can, you talk to lawyers who have litigated election contests. They're going to tell you my goal was to change the outcome of that election. And there are court proceedings. There's state statutes and court cases, published opinions that tell you how to go about doing that legally, lawfully. Uh, and in Georgia, for example, Trump's lawyers filed a lawsuit in Fulton County on December 4th, after the election, after it was certified by the governor, at, but before January 6th counting of electoral votes in Congress. They filed a lawsuit to, quote, challenge the election and get it turned around. And part of the mendacity that happened was the judges of the Fulton County, that is uh, Judge McAfee's
Colleagues.
brethren judges,
Right.
slow walked it. First, it didn't get assigned to a judge until just before New Year's. And then the judge who got the case uh, didn't do anything with it before January 6th. So it sat there with no action taken by the court, even though it's on by definition, it has to be on a short time fuse. So that court sat on Trump's lawful exercise of his rights to contest the election, but now he's charged with using an enterprise to change to change the result of the election. Uh,
Hey, Ship, that sounds like a 1512 violation to me. What do you think?
Don't even start. I remember when all of this happened. I mean, I followed the filing of that election contest, and I looked closely at those Georgia statutes, and that is where it first began to crystallize in my mind that the the fundamental problem that exists, and it exists probably in just about every state, is the state election law for contesting an election does not work for a presidential election, which has an explicit and unchangeable timetable. You
Right.
could leave the office for governor open. You could have an acting governor. You could have an acting city councilman. You could have an acting secretary of state. All of those offices can be left open while the election contest plays itself out. You
Even the members
can't
of
leave.
Congress.
You
Right.
can't leave the office of president open. So
Nor can you
the,
have a holdover of the
right.
previous occupant.
So,
Right.
so the state procedure for contesting an election outcome on a statewide election is ineffectual in a presidential race. It literally cannot be done in the time frame that is available given the electoral college. To make
Which
it
would
even
be
more of an issue, do you know what the remedy is in the state of Georgia?
no.
A new election.
Okay, sure.
That the biggest election contest case I handled was a uh, federal election for congressman, and that's what I was able to get for my client who was running for House of Representatives. He got a new election, but he wasn't running for president. He didn't have the constitutional deadline uh, that, as Ship says, applies to the office of president and vice president. However, uh, there they did manage it in Bush v. Gore,
Yeah, but
and
only
and
with the
and it but
intervention of the court, right?
it
So,
requires a receptive court
right.
to act quickly, to have immediate hearings, evidentiary hearings, and allow prompt discovery. Uh, because an election contest is a civil case. You don't, as a complaining party, you're not in the position of a prosecutor who's managed to or been able to use a grand jury to get control of documents and take testimony from witnesses
You mean
before you
intimidate
file.
witnesses, don't you?
You know you're it's a wing and a prayer when you file one of those. You
Right.
have some inkling that something bad happened, but you don't have real proof of it yet. You may have a person or two who can give you an affidavit, uh, and you may have some suspicious looking results in different precincts, and that's all you've got to go on. So you file your suit looking to get the documents and get the testimony of that you don't have under your control, and you need judicial help to do that. And instead of getting judicial help, Trump got slow walked in Georgia, and that's where, in my mind, the real mendacity is occurring.
Well, this would be an argument for repealing the 20th Amendment, which moved the inauguration for the president from March back to January. And if we can't effectively figure out within the time frame that we have what happened, maybe we should go back to what the original framers said, which is that the president comes into office in March.
Well,
That's
just
a
a
good
second.
idea. I like that.
I don't like it. I'm sorry, I don't like that because if you think about it from an even bigger picture, when that was originally put in place, communications were very slow, and it would take months from across the far-flung 13
Right. Well, that was the
states
original reason. And
to
then we moved it
to
to
put the
January
thing.
because none
All
of
right,
those things were problems
but
anymore. But that
you
doesn't
know we
change the
talked
fact that we have
just
a
a second.
different problem now.
Can I
Yes, go
speak?
ahead.
All right. So the point is, we all know the problems of a lame duck. That's a famous. And if you make the inauguration in April, then instead of having a 2 months, 3 month lame duck period, you've now increased it to almost 6 months.
Right.
That
And there are dangers with the lame duck. That's why we moved it. But I
and
think this is a bigger problem.
up until now, it has never been a
Okay.
problem
Well,
because we
things
haven't had
change. Shit changes.
other than Bush v. Gore in
Mm.
2000, we haven't had a contested election problem until this one.
Yeah, but that's two within one
Okay,
generation.
but the fact of the matter is that the 2020, and I'll be very blunt here, the 2020 election was not stolen. Various states put in
It
somewhat
depends on
irregular
what you
procedures
mean by
because of the
stolen.
pandemic,
Right.
but there's no evidence that it was a stolen election.
It depends on what you mean by stolen, and let's just not debate that. So, but if
Well,
it goes without saying that the reasons why the 20th Amendment were passed were good for the time, but the times change, and now we have this problem, which is a clear and apparent problem because we just had it.
but
So,
in Georgia, for just since we're talking about Georgia, Trump did have his lawyers had testimony and affidavits from election workers who testified that they participated in the manual hand recount in Georgia, and they didn't know how many, but they saw piles and piles and piles of pristine, unfolded, never folded mail-in ballots that appeared to have been machine uh, marked as to which candidate. And one of them even said all the ones I looked at, it was well over 90% Biden. So they identified what they believed were counterfeit ballots added to at some point in the process, and that's what they were counting for the hand recount. Now that's worth investigating. Whether it's evidence of fraud, whether it's evidence that the
whether
election
it
was
turns out
checked,
to be correct or mistaken, it's
but
at least worth
that's
looking into.
that's
Right.
enough to file a lawsuit on. I can
Right.
tell
Of course. I think so
you,
too.
and it deserves a hearing. And Trump didn't get one.
That didn't happen. And I don't like, I'm really only arguing with Steve because I don't like the use of this word stolen, whether the election was stolen or not. I think that it's not specific enough. That can cover too many things. Everyone's talking about different things. I don't like that formulation of it. But setting that aside, um, we, you know, we've got this ruling from this judge, and we did some quick research when it came out. That is an appealable order. But King, did you look at the statute? It looks to me like, and I'm not a Georgia lawyer, but I know you aren't either, but still, you've been looking at it closer than I have. It looks to me like that can be appealed, but only if Judge McAfee certifies it as an appealable order. Is that right?
Yes. Yeah, it sounds like your typical interlocutory order. That is, if it's uh, designated as uh, appealable by the district court, then the Court of Appeals would look at it and they get to decide whether they want to take it or not. So you have to pass uh, two
Both
two
hurdles.
goes. Yeah, pass go twice to get it heard by the Court of Appeals. I doubt that this will.
You'll doubt that the judge will certify it or that the Court of Appeals will take it?
I doubt that the Court of Appeal will take it.
Yeah. Right. They're gonna give a lot of deference to the judge, especially in his appreciation of how the witnesses testified. Right. They always defer um, to the trial judge's appreciation of the credibility of witnesses because he listened to them testify and the Court of Appeals didn't. So that's common. Ship, what do you think? Appeal? Will the defense appeal that? Do you think the government will not?
I
Right.
think they will, because obviously time is to their advantage. I think they will
Hmm.
make the effort, but I actually I don't disagree on the narrowness of the motion's first um, effort, the financial conflict of interest.
Right. I don't either.
It
Yeah.
was, you know, it was a narrow question. The evidence was muddled. Um, I think it's not quite so close on the second question, though, and I don't see his justification for the remedy he imposed as necessarily carrying the day.
Right. I agree.
You
Let's
know,
talk about that.
he
Yeah.
made the comment that, well, you know, to the extent that this, you know, inappropriate public commentary on the effort to disqualify raised, you know, the specter of, you know, a racial motivation.
Component. Yeah.
You know, we can deal with that when we pick the jury and make sure nobody's influenced by it. It's like I'm
Oh, you
not
mean
sure
the
that
jury from
gets.
this county that the church
Yeah,
was in that she was talking to? Right.
I'm not sure that gets her off the hook for essentially, calling the defense racist because I mean, at its core, that's in effect what she did.
Right. And
Um,
he
I,
says,
I,
well, she didn't name any defendant, but clearly she was talking
I don't.
about that defense
Yeah,
lawyer, right? So
yeah. I don't think she's gonna. I think she's got a bigger problem there, and I think the judge decided once he was not going to remove her, he was just going to rationalize his way out of that second
out
problem.
of the rest of it, right. This is
But
what Kingmaker said before, you guys, about this the complaint of her forensic behavior. Lawyers use that, judges use that term. It basically, in this context, it means behavior kind of outside of the courtroom, to just make it the simplest way of understanding it. The speech that she gave to the local church, where she's commenting on the motion inappropriately.
What's your opinion about the book?
Yeah, that was fascinating. He called it unorthodox that she and her allowed her staff to talk to reporters about the case. I mean, I don't know the Georgia law well enough to really, really come up with a conclusion on that. If a prosecutor up here who did that, I think is violating the rules of professional conduct of the court.
Uh, eh, Not only that, but there is a grand jury aspect to what's in that book.
He
Uh,
didn't mention that at all. He just either wasn't
he
that
did
wasn't
not
put
talk
in front
about it
of
in his
him.
opinion.
Yeah,
Right.
either that wasn't put in front of him or he elided over it. But go ahead.
Yeah. Some of the defense talked about it. They didn't emphasize it at the hearing, but it jumps out at you in the blurbs online describing the book
Uh
and
huh.
advertising the book that these authors were given unbelievable access to not only Fannie Willis and her entire staff, but also documents that are not public, documents that would have only been gotten in the investigation, probably through the grand jury subpoenas, or from the January 6th committee, but non-public records that were given to the grand jury or used in the grand jury investigation. And they interviewed a grand juror at length about what went on in the grand jury. Uh, all of that, that's a bigger story that hadn't been told yet as to whether that is Ms. Willis, violated grand jury secrecy and forever tainted the work of the grand jury in this case by
well, and
turning.
there's one other aspect of that, King. Not everything you said is exactly right, but also the defense had tried twice to have some of those records unsealed and made public, and Willis had opposed those efforts.
Right.
And the judge, kept them under seal, and then Willis made them available to the authors.
Right. So now, as we talked about in the Hunter Biden case, where his lawyers were probably inappropriately accusing the whistleblowers of trying to send the district court grand jury information and other confidential information. It's easy to allege a grand jury violation and quite a bit harder to prove, because just because records were presented to the grand jury doesn't necessarily mean that the release of those same records independently to a journalist is a violation. There's very specific rules about what constitutes grand jury information. So um, so it's a little hard to tell from here, but it is very, and the judge picked a good word for it, unorthodox for a prosecutor and her staff to be talking to the press or journalists or authors about the behind the scenes decisions about when and how to indict a case while the case is going on you often see after the fact prosecutors talk about famous cases that they litigated or prosecuted and what happened. But for her to be doing that contemporaneously is inappropriate at a minimum. Now, the judge hinted in his order that he might slap a gag order on her, right? What do we think of that?
I think he'll slap any gag order any defendant asks for.
Yeah, I wouldn't be a bit surprised because she is acting like a complete loose cannon. Ship, what do you think?
Yeah, I think if the defense asks for it, he's gonna say, look, no more public commentary. I don't want you in front of a microphone. I don't want to see it leak to the press.
Then we might get into a contempt proceeding if she can't manage to comport herself with that order. That would be interesting. Aaron, I see you. I've invited you to be a speaker. Go over to your your DMs and see if the invite's over there. So now he also referenced in this order like a bunch of other people who he doesn't actually say, "Hey, you guys, you should investigate her," but he says they might, right, King? Like the bar and the Georgia State Senate, etc.
And then he said they could, and they are actually.
Right, right. That's one of the reasons I think he might have decided to go light on her because it's not like he has to send scathing referrals to these people to look into her. They're already going to do it, and he knows it, right? No comments, you guys?
Well, actually, you know what? I read just not too long ago. The Georgia legislature, both houses, and Kemp signed a modification to the Georgia statute on a disciplinary panel that the statute had provided that the rules and regulations of the disciplinary panel would go into effect once approved by the Supreme Court. And the Supreme Court was sitting on it and not doing anything.
Okay.
And now they just modified the statute and eliminated the Supreme Court's approval.
Cut them out. Okay.
And that, I think that was on the 13th. So what's today? Today's the 17th. So it was just like Thursday of last week that happened. So now there is now a disciplinary panel to review, elected prosecutor, misconduct that exists, or that will. I think Kemp has to appoint the members. He might have already appointed the members, but they don't have the roadblock now of waiting for the Georgia Supreme Court
to do something. Okay, so 2 points. I have attached into the tweet that generates the spaces a copy of the cat on a hot tin roof poster that Kingmaker was talking about. So if you want to know what that looks like, go to the tweet that generates the spaces, and you should see my attached tweet on that. And then also, Aaron has joined us in the speaker box. Aaron, you guys, is a former, we've had him on before, I think twice. He's a former IRS criminal investigator who sometimes helps us with cases. So, Aaron, you had a comment or a question? Go ahead, Aaron.
Oh, I mean, I wasn't sure what you wanted me to talk about specifically.
I have some
belief that she needs to be investigated, and I do think that it's improbable that she paid him back. That's just not, in my experience, public corruption. The amount of money is not important. It's their attitude that they deserve these benefits.
Well, Aaron,
go ahead, Kate.
I have another quote from Cat on the Hot Tin Roof, which I rewatched yesterday to make sure I didn't miss anything good, and I had missed this one. And this deserves some comment by everybody here. Big Daddy,
who's played by Burl Ives. If you have not seen this movie,
he's
Burl
wonderful
Ives.
in it.
Yeah,
Burl Ives is wonderful in this movie.
Yeah, and Paul Newman plays the son, and Elizabeth Taylor the daughter-in-law. Yeah,
and it's got a 97% Rotten Tomatoes critics review. But Big Daddy is talking to his son, played by Paul Newman, and the quote is brilliant. Mendacity is the system we live in,
Right.
which I think applies to what's going on in Georgia.
Right. This is why I'm wondering if this judge, either intentionally or subconsciously, understood that that's really what's going on with this case. And he's used this quote, which is very identifiable from this famous playwright, right, to convey this idea. So, but Aaron, you're right. And that was to Steve's point that, okay, the amount of money is not that much. That makes a difference for what's in front of this particular judge to rule on. But bigger picture, there are other people, the IRS potentially included, who the amount of money is not going to be as important to them as the fact that it could have been, well, maybe not a completely de minimis amount like $10, but any more than respectable amount of money is going to get their attention.
Yeah, I mean, well, the, the amount of money is different for public corruption because in
Right.
the view of DOJ, there's a higher standard. So even a small amount of money would be investigated. But this is not the only problem that she's had. So this is not in isolation. And when you look at all the lying that you see, I mean, there's a reason why they're doing that. Um, and I think that Fannie shouldn't have testified, and I think that they should have just come out and said, "Yeah, of course we were having an affair. So what?" Um, and I think they would have been better off. But the fact that she was so desperate to get in front of everybody, and does seem to be some coordination of witnesses behind the scenes. There's a reason for that, and that's something that would intrigue investigators.
From other places in a way that it really can't intrigue the judge, even if he is interested in it sort of on a surface level, right? All of which is to say, folks, that the fact that this judge disqualified Wade and not Fannie, and that's kind of the end of it as far as the case is concerned, doesn't really mean it's the end of it. It means the judge did what he had in front of him, and it's going to be up to other bodies, other agencies to see if there's going to be any consequences for the way that they've conducted themselves.
I do think this has an effect on the case overall, though, because
Oh yeah, for sure.
it's going to delay it, and also, witness on cases like this, witnesses tend to become less cooperative with the prosecution over time. They just, even victims, like even in cases where I've had victims, people move on with their lives. They just don't want to be involved anymore. And I think with this DA and the problems, that's going to be even worse. But, and more time that passes, the worse that becomes. And then it's easier for witnesses to say, you know what, I don't remember that today.
Right. Now you've got the Trump factor. His cases always, stand out from the crowd. So people are motivated to try to inflict bad things on him. So that may overcome the normal reluctance of people. But you're definitely right. It still is a factor.
Let me
Oh,
just go
yep.
back to the odor of mendacity quote again. That's actually quite a scene. I mean, Burl Ives makes reference to that phrase 4 or 5 times in about a minute and
Yeah.
a half.
Yeah.
If you think, it's when I first read it without really processing it, I kind of, saw it as there's smoke but no fire kind of reference. Like we smell something, but we're not necessarily sure what it is. But I actually think it's more precise than that. I think what he's saying is there is lying going on here, and we all know it because we can smell it,
And
even
we
if
know
we
what
don't
that
know
smells
exactly
like.
what it
And
is.
this is it. Yeah.
Yeah. And I think that by putting it in that way, it's a backhanded slap that is essentially calling the players liars.
Right. That's the way I read it too. And that's what I wanted to help convey to people tonight. Maybe on the superficial level or for lay people, this doesn't seem like a big deal. But for the legal community, some of the stuff that's in this judge's opinion is really bad if you're a prosecutor. And you don't have judges saying this kind of stuff about prosecutors.
Well, the odor of mendacity translates into I know BS when I smell it.
Right. That's the street version of it is, yeah, I know bullshit when I smell it. So, okay. He's just saying it in a polite way that lawyers would tend to put down in writing. So, but I do understand people's frustrations with, yeah, but quote unquote, nothing really happened to them. But Aaron, your point is that, okay, it still has effects on the case. And Ship, your point is, and in the bigger picture, it has an effect on, if Trump gets convicted in that case, it's still going to be the Fannie and Wade sideshow case, is what people are going to see that case as.
Well, and you might pause for a moment to think about how the judge's future decision making might be influenced when weighing the arguments between the two sides when he's now decided that one side has lied to him.
Right.
Well, I think it'll be interesting, potentially, because I agree with you, Ship, that the defense's game strategy is to stall this out, prolong it as long as they can. So I think the judge's decision is the best they could have hoped for. I don't think that there's any realistic hope that they could appeal it and have it become better for them. But I could imagine them moving to appeal, asking his permission to certify it to appeal simply as a delaying tactic. And I'm not entirely sure, but that he might go along with that and leave it up to the Court of Appeals. As Leslie pointed out, not only does he have to certify it, the Court of Appeals would have to accept it. And I don't think they would accept it. But in the meantime, you'd burn another couple of months in the process. And if I'm the trial judge, I'm in no hurry to see this case go to trial anytime between now and the election.
So was it today or yesterday I saw that Wade, in fact, then turned around and resigned? So that has happened. Is anybody,
Friday.
was that, so that was Friday. Sorry, I've lost the day
Yeah,
here.
and he resigned the afternoon the opinion came out.
Okay. So
And
any indication?
he resigned. He was booked to be on Meet the Press today, and then he canceled before
Aha.
appearing today.
Right. Because maybe he got an actual lawyer who told him, "Are you out of your mind? You need to zip the lips." Oh, good grief. Well, any indication that anyone's seen about, so now what? Who's going to pick up the torch?
Well, there's an election going on. Fannie Willis has two viable competing candidates, and Judge McAfee also has a somebody who is contesting him in the election.
Okay.
So, and I don't remember when the election day is, but it's coming up pretty quickly, I think.
Okay.
Georgia's got an odd 3-date election calendar. I can't remember exactly how it worked out, but I think you have to get over 50% in the primary in order to become your party's candidate. And then if you don't get over 50% in the primary, the top two go to a runoff. I think these come up in June, because I remember when because Fannie Willis won, she ran and won on the back of her crazy predecessor who indicted the two cops for the Wendy's parking lot shooting in the summer of
Right.
2020.
Right. Good grief. I remember talking about that. Yeah.
Okay. She ran against him for his own history of, this is the guy, we may have talked about this before, I can't remember his name, but he
Me
was like the
neither.
4-term or 5-term DA, had been there for 28, 30 years, and was running a nonprofit that was approved and funded by the mayor, that paid him a $200,000 a year salary as the CEO of a nonprofit to deal with at-risk youth at the same time he was the elected DA.
Right. Yeah, I forgot about that. All right. CNN says,
So she ran against him in the Democratic primary. She did not he, I think, actually led, but neither one got 50%. Then they had an August runoff, and then the winner of that goes to the November
Yeah.
general.
Okay. CNN says that she has an opponent in the Democratic primary, which is May 21st. And then the general election, in which she'll run against whoever the GOP guy is or gal, on November 5th. So her most, the one that's coming the closest, soonest here, is May 21st. But what I was really asking is, who's going to be leading the prosecution now? Is the office going to assign somebody else? Do they have to hire a new contractor? Has anybody heard anything about that?
Norm Eisen is going to come out of the closet and actually appear, since he's been doing all the work behind the scenes anyway.
No, that's not true. They're going to hire you, Ship. Actually, look, the fact of the matter is, I've been, well, Ship's been a prosecutor too. In fact, longer than I have. But the fact of the matter is that Nathan Wade didn't put this prosecution together.
Right.
He doesn't have the credentials and the background and the know-how
to do it.
To do it. That's become painfully apparent. So there's been some career prosecutors in that office that have been honchoing that prosecution. And what I suspect is that they're going to continue to do it. You know, she may go out and try to get some high-profile trial attorney to come in and schmooze the jury, which is what she tried the first time when she talked to Roy Barnes, the former governor. But nobody's going to, no good lawyer is going to touch that case with a 10-foot pole at this point. And Roy Barnes wouldn't in the first place because he's no fool.
Except Norm Eisen.
Yeah.
Well, okay, but that fits in with what I just said.
That she has as a special prosecutor. I don't remember the man's name, but he is supposedly the RICO expert in Georgia,
Okay.
and he's the one that's been arguing the motions.
I see.
He and or
He's
people
the one
in
that
it.
did her no help for her, as I recall.
Yeah, right. Yeah, he did not appear in any of the disqualification hearings or on the papers,
Okay.
but on the merits of the case and the demurrers and special demurrers and
I see.
whatnot.
Yeah.
He or somebody in his office have appeared, and they've done a good job.
Yeah, there's two other lawyers that were hired by her on contracts similar to Wade's contract, and they are noted RICO specialists, former state prosecutors, either in Fulton County or in other counties, and are noted.
So they're doing the work in the office
Georgia State
behind
RICO,
the scenes,
right?
Yeah.
Which only raises the question: why the hell did Wade get $1 million?
Right. It's not like they didn't have the expertise in her office.
Raises the question. The question has long since been answered.
Didn't Trump answer that question? He's like, she called him 2,000 times. He must be good at something. I laughed so hard at that. Let's all wonder what that was. Okay, you guys. Well, enough about that. Let's talk selective prosecution. Okay. So, King, were you following what Judge Cannon's hearing?
I've second or third hand, yes. I've read what was posted about it, and I read Trump's team's brief on selective prosecution and Weiss's reply to it.
Okay.
And which, by the way, the reply came after he had the benefit of her report,
right,
but not Her's testimony.
Okay.
And,
all right, and that's the other topic we want to talk about. Should we talk about that first before we do selective prosecution?
I think they go together.
Okay. Well, we can just move back and forth between both these topics then. Ship, did you follow or have you read any of the pleadings? I know you're very busy, so if the answer is no, that's totally fine. But I just wondered, did you?
I only saw basically what some people in the courtroom were
Mm-hmm.
posting on Twitter. I did not read the brief. I know this subject relatively well. I
Right.
did read, but didn't realize we were going to do this. I did read Judge Cormac Carney's
Yeah,
opinion in the
I did too.
California case.
Yeah, we can talk about that for sure.
So I think, as I said on X, he gave her the roadmap if
Yeah.
she wants to go down that path.
Right, I agree. All right, so folks know what we're talking about. Selective prosecution is a defense that lawyers raise, which is not really a defense because it's not like I didn't do it, you got the wrong guy, or I didn't have the right mens rea, or I didn't have the right state of mind, or you can't make out this element of the charge. Those are all defenses. You might have a defense that you got coerced into doing something. You might have the First Amendment as a defense. Those are defenses, most of which you would raise to the jury, some of which you might put in front of a judge if it was a more legal type defense. Selective prosecution, people call it a defense because it is raised by the defense lawyers, but it's really a legal argument, not that the person didn't commit the crime or that there wasn't a crime, but that the government is prosecuting some people for a crime in circumstances where they do not prosecute people who are also committing that same crime for some reason that isn't acceptable. So they're prosecuting people who commit, I'm just going to say, it's usually a speech related type issue, actually. Um, they're not going to prosecute some people for, let's just say, trespass because they're white or black or brown or male or female or Jews versus Catholics or whatever. Okay, so the idea is everybody's doing the same thing, but only some people are getting prosecuted for it. And the reason they're getting prosecuted for it is a reason that we don't allow. Um, and this motion, unsurprisingly, almost never wins. Like defense lawyers almost never win this motion. You can raise it when you have the right facts. It's one of the theories that when I was practicing, I would tell the clients, well, there's case law on this, and the judges do a great job explaining what it is and how you have all these constitutional rights and protections, and that it's really bad if the government does this thing, and then they always conclude that that's not what happened and you lose, notwithstanding this really nice theory. Nobody ever wins this argument. So this is what's going on. Selective prosecution means the prosecutor is selecting people to prosecute for an improper reason. And typically the reasons are, and the law says that these are the kinds of reasons that the court should use to dismiss. This is why defense lawyers raise this, is because the remedy is the case gets pitched altogether. It gets thrown out. So the current case law says the kinds of reasons that prosecutors have that are not okay and that the judge should therefore throw the case out are things like race, gender, religion, and more broadly, the exercise of constitutional rights and privileges, right? So if a prosecutor's office was, let's say, only bringing cases against people who had previously, um, done some kind of right to protest something else that the prosecutor was doing. So if you brought cases against the prosecutor's office and you won them, and then they turned around and they were only prosecuting the people who brought those kind of claims, that might be sort of a non-race or non-gender based example. But the classic ones are race, gender, religion. But as a practical matter, this selective prosecution argument tends to get raised when you're talking about a free speech type situation. So the people who are doing the obnoxious stuff that the establishment doesn't like are the ones that are getting prosecuted for things that might be protected by the First Amendment. That you see it more often in that kind of a case. So Trump's argument isn't so much about speech, though, right? King, tell us what is Trump raising as the reason for the quote unquote selective prosecution?
Well, before I get to that, this came up at the hearing, and it wasn't a hearing on the motion to dismiss for selective prosecution.
Right. It was not the hearing on that motion, but the judge wanted to talk about it at the
Judge,
hearing.
and the reason she wanted to talk about it was the motion that she was hearing was the motion that claimed that the Espionage Act, as it applied to presidents, as it applied to President Trump, was unconstitutionally vague, which means that that a reasonable person sitting in Trump's chair could not figure out what's legal for him to do and what's not legal. And part of that argument entails some history of the presidency and the fact that Trump is the first former president to be prosecuted under this act, despite the fact that every president that we know of, at least since going back to Clinton, have taken or been found with or found to possess classified documents.
I think it goes back to Reagan, actually.
To Reagan, that's true,
Yeah.
Reagan, and nobody, and so all of these former presidents have walked out of the White House with classified documents, potentially national defense related documents, as specified in the Espionage Act, but nobody has been prosecuted, let alone investigated criminally, except Trump.
Right.
So,
So let me
and that
say, so people understand, the Espionage Act was originally passed after the First World War, because that's when the Congress in modern times got real bent out of shape about like spies and people selling defense information and taking pictures of, defense installations and all kinds of stuff. And so they passed a statute which both the Criminal Defense Bar and the DOJ and the National Security Bar all agree that there are portions of that statute which has multiple sections. There are portions of that statute that are almost certainly unconstitutional based on kind of theories that the Supreme Court after the First World War has developed about vagueness, about how much of a state of mind, mens rea you have to have. Okay, so that statute is pretty old in relative terms for federal criminal statutes, and there are multiple problems with it. I will point out, I think that Julian Assange is charged under one of the provisions of this statute, the one that is probably the most problematic constitutionally. So, but the reason that President Trump's lawyers were arguing that it's unconstitutional is a different constitutional argument from the section that you would use, that Julian Assange would use. So, but all of which is to say, this motion that some people and lawyers on the left have characterized as, oh, this is crazy to say this statute is unconstitutional. It is not at all crazy. There is existing scholarship and concerns from the Department of Justice itself that this statute, because of when it was passed, is constitutionally suspect. So his lawyers did a good job for him. The judge didn't agree on his particular facts, but that was a good motion to bring. So she denied that motion, right, King?
she denied it,
Yeah.
but she said without prejudice. That she specifically put in her order that you can refile this when we get to the point where we're trying to craft written
What we're going to tell the jury.
instructions to the jury.
Yeah.
And I'm going to be asked at that point to tell the jury what this law means
Right.
in the context of a president,
Right.
because one aspect of it is one element is the possessor of the secret stuff, so to speak, has to have possession of it without any authorization and has failed to return it to the person who's supposed to get it. And it's those two sections, whether he has authorization and who the heck do you give it to under these facts, Is it something that, what if Trump declassified it? Does that mean he can keep it?
It
Does
depends on
any
whether he's in office or when
Yeah,
he's out of
right,
office and what,
right, and all of that's left unsaid in the law,
right.
and Trump's argument is not only is it unsaid in the law, it's vague as to whether I can take it to Mar-a-Lago or not, and once I get it to Mar-a-Lago, who do I give it to? What law says I have to give it to anybody? Uh, particularly if I've declassified it or declared it to be my personal stuff, uh, those are not spelled out in the law,
Right.
and there's
It's
no.
very complicated. And
It's
other thing,
complicated, and which raises the issue of what about these other presidents who have been in similar situations? They've got their hands. They've like Clinton had a sock drawer full of tapes
right.
where he dictated
Yeah.
into the tapes all kinds of classified information,
Right. And he
and it's
took the
in his
position those
sock
were
drawer.
personal records that,
And the court said those are personal. You have a right to keep them.
right. That's what they said about Reagan. I mean, the court
Yeah.
didn't say that, but the Justice Department said Reagan's
So,
diaries were for his personal records. Right.
but there was no written order signed by Clinton saying the stuff in my sock drawer is personal.
right.
Same with Reagan.
right.
Uh, so, uh, so the judge was worried about how do we describe to the jury what the law is
Right. And
and
she
what they
should
have to
be
find
because,
to
yeah,
find him guilty.
right.
And so
She
he
should
said,
be.
"Yeah," and said, "If we get stuck,
uh-huh.
file your damn motion again,
Right.
because I may revisit."
And one thing that people need to understand, we live in a world where a lot of this stuff is highly regulated, right? The classified information. But this statute doesn't even talk about classified information. It talks about defense information because this statute was passed before the current regulatory scheme that governs the handling of classified information and the issuing of security clearances and all of this. This is, I think a lot of you guys know, this was my area of expertise as a lawyer. And people will say, well, everyone knows you can't do that. But the answer is that this has changed a lot since First World War. It's changed significantly after the Second World War. It changed significantly again during the Clinton years. And it continues to change the law with respect to classified or defense information. But the other thing is that a lot of what normally applies to normal people in this situation, stuff that you would get prosecuted for if you were just a guy working for the DoD or a defense contractor, does not apply the same way, not just in practice, but legally to the elected and appointed members of the government. So the normal rules that, well, I'd lose my job and I'd go to jail because if I did that, well, that's true, but that's not what we've done with in general. There have been some exceptions, but in general, that's not what we've done with these high elected officials. So go ahead, King. So tell us, why did Judge Cannon go off into the selective prosecution, even though that wasn't the motion in front of her?
Well, because it naturally devolves into, well, what is a president supposed to do and what's he not supposed to do when he's leaving office? If he can take some stuff with him, but not other stuff, who decides? And there you have a separation of powers issue, because the courts have held and that until his term ends, which is noon on January 20.
Although we're going to change that back to March.
Yeah. Okay. But until he leaves office legally, noon on January 20, the president is the president, which means he is in charge of the entire executive branch of the government. And no other branch, no court, not Congress, can tell him how to do things that he has exclusive discretion as the executive to do. And one of those things is to decide what's national defense information, what's to be classified, how it's to be unclassified, what to do with the records. Those are that's in his bailiwick. He's and until he leaves office, nobody can second guess him. That's what generally the courts have said that. Uh, So Trump's argument is, heck, I did what Mr. Clinton did. I sent them to Mar-a-Lago when I was still president. And by sending them, I declared them implicitly that they're my personal papers. By
And
the way,
that's what happened with Reagan, which Herr goes over in his report. Reagan
yeah.
didn't issue an order that says my diaries are hereby declassified. He just took them with him when he left.
Well,
And
And,
and
and
everyone
historically, that's what happened. All the presidents
right,
going way back, they took their papers.
right. So
And
Steve has a point here. You want to jump in?
yeah, because let's be clear. It's one thing to say that Reagan's personal diaries are his personal property, or that Clinton's tape recordings are his personal property, or as Herr said, that some of Biden's written things
Notes.
were personal diaries. But the documents that Trump took were not his personal diaries, they're official documents.
Well, and there is a distinction, this is fair, between a government generated document that's classified and the office holder, member of Congress, executive branch member, creating material that contains classified information derived from those documents, definitely, but in the nature of a diary or a tape recording. That there is a
and,
distinction there that makes a difference.
and what about in modern day copies?
Right.
Photocopies of original documents that clearly belong to the government, designed to be kept by the government, but the president decides for his personal records he'd like a copy.
Right.
Does
But
he
it's
have a
not,
right to?
and that's open questions there that are complicated, right? So, like, he's not depriving the government of its record. So, in that sense, that's no problem. On the other hand, you can't copy classified documents and take them with you. Like, that's the rule. You're not allowed. The question is the president somehow not subject to that rule? And we've kind of, in both circumstances, both when it's easier to see that that's the right answer when it's a diary or a tape, right? Or notes. It's harder to see that that's the right answer when it's an actual document, but the answer might still be the same.
Well, Leslie, let's stop for a second because you just said something about what the rules are on classification, and you're the expert on this. Don't all the rules on what's classified and not classified ultimately trace to the president rather than a statute?
Right, absolutely. The courts have said this is part of his power as commander in chief, keeper of the nation, and all these executive orders and non-disclosure stuff, and all the stuff that everyone else who's cleared has to agree to, just do not apply to the president.
Because they flow from an executive order, right?
Right, those things flow from an executive order. I mean, yes, that's the mechanism by which they're delivered out to the peons, and that executive order specifically says it does not apply to the president. I think also the vice president, if I'm remembering it right. So you've got the power, and then the executive order, is the evidence of like what the rules actually are. So it's very, very complicated, way more complicated, I think, as a lawyer who used to practice in this area,
I,
than
I,
these leftists are making it out to sound like.
and the historical picture here is not something without meaning.
Right, I agree.
Because you've got for decades, centuries even, presidents walked out of their office with all of their stuff, all of their papers, and it was up to them as a private citizen whether to donate it back to the government or to create a presidential library, uh, or have a bonfire. It was their choice.
Right, and that existed up until Nixon, right? It's in the wake of Watergate that the Congress passes the Presidential Records Act.
Exactly.
Yeah. Now, Herr makes a distinction in his report that yes, that's fine, but then you have this almost like parallel series of regs and laws pertaining to classified information that they go together, right? They don't contradict each other. I tend to agree with that. But these other folks seem to want to say that, well, those normal rules apply to the president. He has to be held to the same standard. And that's just never been the way that it works with respect to classified information.
Now, and as to the same standard,
Right.
that inherently raises the selective prosecution
Right.
issue, particularly with Biden, because you've got current President Biden, who, according to her, uh, illegally took and kept classified information over the past 40 years.
Well, it's not clear to me that he thinks Biden illegally took it because he had a right to have it in his home.
Not as senator. In no way he had a right
Yes.
to have it as senator.
Right, exactly.
He could
The
only
old stuff, I agree with you. Yeah. Yeah.
the only way he could get that out was to sneak it out of a skiff or have somebody
One of his staffers did it for him. Right.
do it for him, right? So,
Or they did
uh,
it without his knowledge. Could be that too, but it's one of those three.
and that's where the selective prosecution comes in, because there you have a motive for selective prosecution. You have a current president who's been accused of doing some of the same things Trump is being accused of. And not only is he not prosecuting, but his executive office, his executive department through the DOJ is prosecuting his opponent.
Right. Now, Her explains what he thinks the differences are in his report, and I'm not sure I'm completely persuaded by that, but still just trying to continue to sort of set up the issue. The question is, one of the questions is, what's the comparator? So it's easy to see, well, you're prosecuting, you know, you're prosecuting women and not men, right? Or vice versa. That's easy to see what the distinctions are for the same conduct. Okay. It's based on sex, men versus women. But the question here is, who are we comparing President Trump to? The government seems to want to compare him to like other people, other maybe government officials, high ranking government officials, but other people who are subject to the rules on and the laws on this. Whereas the defense seems to say, no, it's a smaller class of people to compare him to see if he's being selected out, and that's just the former presidents.
It is the former presidents, but the focus is more on Biden.
Right. Who was the former vice president, right?
Yes.
Right. But what I'm saying is the government seems to want to broaden it even more than that and say, oh no, we're not selectively prosecuting him because we would have prosecuted other people who did this same thing that he did. And it's like, yeah, maybe, but not the former presidents or vice presidents.
And you ask, what does the government say distinguishes Biden
Right.
uh, from Trump? Two things. One is the uh, Trump's obstruction of justice behavior in,
Allegedly.
yeah, fighting the subpoena and hiding documents and lying to his lawyers as to where the classified stuff was being kept at Mar-a-Lago. That's one. That Biden didn't do that. He allegedly cooperated after keeping them secret in various places for
Right.
40 years. Uh, the second is that, uh, and here, uh, uh, Smith, the special counsel, gets way out on the limb, in my opinion. He says there's basically Biden didn't commit a crime because he didn't have the proper willfulness. That's what the special counsel found,
You're
which
talking
is
about
not.
her now, not
I mean,
Smith.
yeah, her found that the elements of the crime were not met with respect to Biden. Uh, Mind you, the only reason the elements weren't met was because Biden doesn't remember anything, and he didn't think he'd be able to get a conviction against somebody apparently senile. That's the only reason. Other than that, all of the elements of the crime were met in both cases. They willfully took the documents. They knew they had them. They knew it was classified. They knew, and they disclosed the classified information to third parties who weren't entitled to see it. Uh, and Hur has that on tape in Biden's voice telling his ghostwriter that, "Oh, I found the classified stuff in the basement. Let me read you some of it." And as he's reading, he says, "Oh, some of this is classified, so be careful."
Right. Now, what's interesting about that is by not showing the ghostwriter the document, but simply reading it to him, he saved himself because the statute technically doesn't punish the oral transmission of classified information. This is the 793 section. If it's not with the intent to do harm to the United States.
It saves him as far as disclosing, but
Right.
it doesn't save him as far as willfully retaining
Right. So
something you're not supposed to have.
you've got taking, retaining, and disclosing, and those are three different things under the statute, and they require different kind of sub elements or additional elements. So the point I'm making is that in terms of, because you said he let the ghostwriter see it, he did not. He let the ghostwriter hear it, and by making it hearing instead of seeing, technically, he's not violating the disclosure part of the statute. But I mean, I don't think he knew that, Joe Biden, right? He might have just had an instinct that I probably shouldn't show you these documents, but let me tell you what's in them, right?
But the fact that he described them as classified, the
Mm,
fact that the information he was reading to the writer was top secret information,
right.
national defense information that fit the definition, had to do with our plans for the Afghanistan war.
The surge. Yeah.
Sir, it. Uh, I mean, Biden had no more defense for doing that than Trump does. Uh, Trump has the argument, at least, that as president, he was entitled to implicitly, he claims, declassify it or declare it personal as opposed. And I don't know how far that gets, but it Biden didn't have that argument.
He doesn't have that defense in his toolbox, right? All right. Well,
Correct.
I want to bring Ship in here. Ship, let's talk about the selective prosecution. So, and we can bring in Judge Cormack's case. Do you, in your experience, did you see any selective prosecution cases that were like the one that Trump is raising, where it doesn't seem like it's so much a constitutional right or race, gender, or even speech? It's more like political partisanship or political affiliation. I'm not sure the current law goes that far, but you probably know this area of the law better than I do. What do you think?
No, I don't think it does, except to the extent that the partisanship is manifested in political advocacy.
Speech. Yeah.
Yeah, and that is really, I think, what was at the heart of the Los Angeles case, which oddly enough is a political protest case from 2016 that
Right.
was prosecuted by the Trump DOJ
Right.
originally.
Right.
Now, the target in that case fled the country and was gone for a long period of time, then finally came back into the country after Biden had taken over the presidency. So it ends up being handled by the Biden Justice Department and ends up being dismissed.
So tell us about that case, and let's help the listeners understand how it fits more comfortably into sort of the existing case law about speech. I'm not
Yeah,
sure if that case is rightly decided either, but it to my eye it's easier than Trump's case. So to help
yeah,
us understand it.
it was a 2016 political rally that turned violent. I can't remember one of the groups was called By Any Means Necessary, and I think that was the progressive liberal group. and I can't remember what the other one was, but it was it was the government called it, a right wing protest group. So you had your basic, right wing versus left wing clash in a public location, and if I'm not mistaken, it was a 231 count. It was declared a civil disorder, and at the end of the day, uh, I can't remember how many people, but there were two defendants in this particular case. And one of the issues, yeah, well, there were two defendants charged, both of whom were part of the right wing protesters, but there were multiple participants among the left wing protesters who were captured on video, engaged in same or similar conduct. Their identities were known, and they were never charged. And one of the issues that the judge seized upon in dismissing the prosecution was in the press release announcing the arrest, the government made a big deal over the fact that they were part of a right wing extremist group, basically called out their political orientation as a publicly stated justification for indicting them, when there were counter protesters of the opposite political orientation not charged, even though the evidence was the same. Um, and so this motion, or I didn't read the motions. I just read Judge Carney's opinion. There was it was very heavily sourced in the sense that there had to have been an evidentiary hearing at some point because there were references to transcripts and so must have taken testimony from maybe the investigating agents as to their motivations for investigative steps they took, but ultimately, he did, and now Judge Carney's been around for a long time, and just as an aside, he was an All-American football player at UCLA in 1982, 2 years before me. We were in school at the same time. I was a very bad baseball player, and he was a very good football player.
He's a Bush appointee, I think.
Yeah, and I didn't know him, but he was very well known on campus, and I think he went to Yale Law School after playing the NFL a short period of time, and has been a federal judge for 20 plus years, and is very well known in Southern California. A little bit of an iconoclast, probably leans a little libertarian, and had no problem calling the Justice Department out here and dismissing the case based on First Amendment grounds, selective prosecution. The government immediately, it turned into a little bit of a tussle in the immediate aftermath because he dismissed the indictment and ordered the defendants released.
Right,
And
and
then
he
the
did that
government,
on February 21st of this
right,
year, you guys. Yep.
yeah, and then the government immediately appealed to the Ninth Circuit and sought to have him stay his release order. And he said, "Well, I've dismissed the indictment. On what basis do I have to stay my
To hold
release
these
order?"
guys, right? Yeah, and so people know the government never appeals on the same day that the order is issued, never, ever, and they appealed literally on the same day.
Yeah.
Um,
So I think the Ninth Circuit did enter an administrative stay while the
yeah,
briefing was done. I didn't see the outcome of that. Um, but the government's justification for wanting to hold the defendants was that the defendant. I think there's only one defendant involved, although two were dismissed. One they were anxious to keep in custody. That particular defendant had fled the country to avoid prosecution previously, so they said, if you let him out, he's headed for the border again.
he's going to sky up, is what defense lawyers would say. Well, so in general, the government, when it wants to appeal to a circuit, has to get the approval of the Solicitor General's office because the Solicitor General does not want the Justice Department making bad law by appealing cases that, okay, you might win in the circuit and then the Supreme Court's going to slap that down and make law that the DOJ doesn't like. So it's unusual for them to appeal on the same day. But the reason they did that here is what Ship was just describing. They're afraid this guy's going to flee the country. So, well, what do we make of this judge's order, do we think it does fit correctly under the selective prosecution rubric?
I think he pointed to the government's reliance on the content of political speech
Right.
as a public statement for why they were indicted, and the absence of a justification for why similarly situated defendants of a different political persuasion were not. So on that basis, he found that it was a prosecution based upon protected First Amendment activity, or they were improperly selected because of their viewpoint, as opposed to similar actors, similar offenders who were not selected,
And
and that's misconduct.
it does look like viewpoint discrimination, but why I'm sort of hammering this point is that as I read the established case law, it's more closely hewed to speech than this case seems to be. He seems to be, even though the government relied, yes, on their statements, it's more like these guys are on one team and the guys who are on the other team, you're not prosecuting them. And sort of affiliation or partisanship becomes almost like a proxy for speech.
Well, it's political speech.
Right.
I mean, political
Yes.
speech is almost always going to have a point of view.
But
You've
they're
got
not being
another.
prosecuted for what they're saying. They're being prosecuted for participating in a riot. It's just their reason for being there
Well, I mean, we know that
is partisan.
burning a flag is free speech. So
Right. Actually, I agree with that as a libertarian. I think it is. But do you see what I'm saying? Like, the essence of a selective prosecution defense is not that this person didn't do the conduct. It's that other people did it too, and you're not prosecuting them. Which, like, in your normal traffic ticket situation, doesn't work.
right. But the problem is that the government stated the reason for why one and not the other was being prosecuted.
Because they were
And
neo-Nazis and white
Yeah,
nationalists and
except
correct.
I'm not sure that I think that that's factually correct. I don't think the government went that far in its press statements. I'm 99% in agreement with you, Bill, but it seems to me that to return to Leslie's point, that what got the judge's attention was that nobody from Antifa or a comparable organization on the left was being prosecuted, whereas these guys on the right were. And there was strong evidence that it's based on 3 different demonstrations. And at these same 3 demonstrations, not only were these right-wing guys present and looking for trouble, but there were left-wing guys present and looking for trouble. When I say guys, and in fact, some of them were women. I'm not trying to be sexist here. And he didn't think that was right. And I don't think it's right either. But I must say that it seems to me that in terms of where the existing law is, that this was a real stretch.
it's an extension of what the current case law, I think, supports. And I'm with Steve. I'm not sure that that's not right, but it's a new way of sort of looking at this kind of emotion. And that's the backdrop against which Judge Cannon seemed to be operating in the Trump case. Um, so,
Yeah,
and I
I
know
think that
the right has been energized by this judge, California judge, right? Because
yeah.
it has seemed unfair to people that, the left riots, that's not a problem. The right riots and everybody's in the gulag, right? So from a big picture perspective, of course, that's terribly problematic. But I'm intrigued as a lawyer by this idea that we're using this kind of motion in a way that maybe is new.
Uh,
Yeah,
uh,
I've heard, or I've read, I can't remember exactly, that Judge Carney may be preparing to retire and leave the bench,
Aha.
and this might have been sort of a commentary by him
Swan song.
Not saying it's a commentary on January 6th, but the juxtaposition that I hear often in political circles is, why didn't people get prosecuted in the summer of 2020 for burning down the cities, but everybody that stepped on the Capitol grounds is a potential target for January 6th.
Right.
So and yeah, I don't know. I don't. I understand that the crime is the violence,
Right.
and selecting one violent offender out from another violent offender, that's a matter of prosecutorial discretion. And that's what the government argued.
I have a
Go ahead,
question.
King.
The is the pile-on issue as to Trump relevant in this on this issue? The government makes a strong argument that well, look, we don't have similar obstructive behavior by Biden or any of these other presidents. Only Trump tried to obstruct justice and defeat the subpoena that way. Uh,
Well,
on the
and
other
then
hand,
her points out that Petraeus also lied when he got confronted, and they ended up wringing a misdemeanor plea out of him.
well,
He
that
was,
yeah. And on the other hand, they piled on with Trump with I don't know how many over
right.
40 felony charges,
Yeah. Which is just
which
absurd
which
on its
are
face.
which are practically indistinguishable from what her found Biden doing.
Yeah.
Yeah.
All right. So I want to talk about that, but I want to sort of have the trail of breadcrumbs make sense so people understand. So this judge in California, Cormac is his last name, right, Chip?
Oh, Cormac
Carney.
Carney
Oh,
is his
his
name.
first name is Cormac. I keep getting that
Yeah.
backwards. So he issued this opinion, which has sort of highlighted this question of selective prosecution in federal court, really kind of for the first time on this theory. And I'm not saying he's wrong. He may very well be right. And I'm completely sympathetic to what the problem is and the problem as he's described it. The point I'm making is that it's a bit of an extension of the existing law about selective prosecution. Um, and he's just a district court judge. He's not on the Court of Appeals. He's not on the Supreme Court. But that's how issues get floated up for the higher courts to rule on, right? So he's done this interesting opinion about this, and then Judge Cannon seemed to be. Did she? I don't know if she actually mentioned it, but it seemed clear to me from the discussion that she was animated over this issue of selective prosecution, and maybe thinking along this same lines that it's not permissible for the government to prosecute people because they don't like their religion or they don't like their race and they don't like the words that are coming out of their mouth. And so far, maybe we haven't had to say it's also not okay if the government prosecutes people for their partisan affiliation. But maybe now we're going to have to start saying that as the courts, um, as judges, that this is also against the rules and you can't prosecute selectively on that basis. King, does it seem to you that she might actually rule that way?
I I wasn't there, and I don't have a transcript of what she said, but uh, the reports are that the selective prosecution issue raised its head during the unconstitutional vagueness argument the morning of the hearing, and it's hard to separate vagueness versus selective prosecution, and the judge has not set a hearing on that motion, and it's still pending, and she hadn't ruled. But it from the quotes that I've read from her, uh, she's considering it seriously.
Yeah, right. That's what I thought too. Very seriously, she seemed most unhappy. So, and obviously, this is in part spawned by her report and testimony, right? So let's turn to that fully then. So, King, you've raised a couple times this issue about, well, somehow Biden, as a feeble old man, gets, out from under this, that he didn't have the mens rea for it, even though he did all of the elements of the offense. So let's bounce that around. And Ship, I want to ask you, as a longtime former prosecutor, about this, because I have 6 years experience as a defense lawyer, where I can tell people defense lawyers make these arguments that Hur is talking about on Biden's behalf. I have gotten cases not indicted, that you get what lawyers call a declination, right? Where you talk to the prosecutor and you persuade them not to indict your client based on the arguments that Hur is making in his report. People are like, that never happens. And I'm like, I personally have done that multiple times. So don't tell me that that never happens, right? It is a factor whether or not the person has the required mental state and whether the government can prove that or not. Now, it's a very, very uncommon occurrence. I would say rare even, but I personally have done it, where the client is in such a bad situation that even though the government may think they can prove all of the elements, you're still able to persuade them, yes, but you shouldn't prosecute this person, either because the principles of federal prosecution dictate that you should take a pass, or because there's a mens rea problem.
Well,
So to me, this was the most powerful in her assessment that he had to make on the retention issue, not the um, taking or the disclosing, but on the willful retention. So, can
can
you
I come in?
jump in? Yeah, go ahead.
Yeah. To me, there was a fallacy, a logical fallacy there, because Her, on the one hand, testified that he had evidence in the form of a tape recording showing that Biden knew he had classified information and was willfully holding it.
At least on the date of that recording, I agree.
On the
That
date
was
of
the
that
best
recording,
evidence. Yeah.
on the date of that recording. And Her then points to Biden's absence of memory and his forgetfulness on the date of the interview, which was several years later. Uh, Nobody really asked him or pressed him on what was the difference. Did you see the same memory issues and cognitive issues as of the date of the recording? He never said he did. He said just the opposite. He said, I found a reasonable juror could find him guilty on that evidence. So you have the issue of, apparently at the time this offense was committed, until some point when he started losing his memory, uh, he had sufficient mens rea to be found willful, uh, in violation of the law. And at some point, he lost his
He
memory.
lost, right. He lost the willfulness
He
component.
lost at least
Right.
he his memory failed such that Her was afraid he could not prove he had the willfulness element.
Right.
Uh, when did that happen? We've heard no evidence as to when that occurred. And if it occurred uh, within the statute of limitations, uh, I don't see any reason not that he shouldn't prosecute the guy.
And so people know the normal statute of limitations for almost all federal crimes is 5 years from the commission of the offense. For the 793, this Espionage Act, it's a 10-year statute of limitations. And the government will often take the position in those cases that the willful retention is like a new offense occurring every day, that you knew, that you took, that you still have willfully, you're holding the document. So if you took it 20 years ago, but you're still holding on to it, right? And and you are, and you're saying, screw it, I'm holding on to this document every day, or whenever you happen to think about it, hey, it's out in my garage, whatever, that is a violation that kind of restarts the operation of the statute of limitations. So But Herr mentions in his report, he thinks they'd have trouble with the shorter statute of limitations statute, which is 18 USC 1924. That's the one they forced Petraeus to plead to as a misdemeanor rather than a felony, because it could be either. But on the 793, the Espionage Act claim, they could go back and on this continuing violation theory for quite a while in terms of statute of limitations.
Well, let me jump in here because I want to make something clear that I don't think is clear to most people. And that is, and Herr was all over this. That is that to the extent that Biden's got these documents, during the period of time he was vice president, he was legally entitled to have them and to keep them in his house. So that wouldn't be a violation. So during the 8 years that he's vice president, they cannot use that as a basis for a prosecution. And likewise, ever since he's been president, it's again legal for him to have those documents and to have them in his house. So they can't do it on that. In order to prosecute him, they have to rely on the period of time that he was neither the vice president nor the president, which means the Trump administration from 2017, basically end of January, start of February, until this January 2021 when Biden comes in as president. And they have to show that during that period of time that Biden knew that he had these documents in his possession and continued to hold them, knowing that it was unlawful for him to do it. That brings his memory squarely into play.
Which is why they were talking about the 2017-2018 timeframe. And then he makes this big gaffe of saying, well, you have to understand during that time frame, my son was either serving or was dying, which of course is way before any of that time frame. Right. So,
but my point is the conversation he had with his ghostwriter happened after he left office as vice president.
Right. It's in like that first year, isn't it? After
it was in 2017.
Right. But and again, I want to make, I've looked at the report. I haven't read it exhaustively, but I've skimmed it. That is an extremely professional report. And he exhaustively analyzes the various sorts of documents. And he found that on a number of the documents, there's different sorts of documents that come at different times and all of that. He found that aside from Biden's lack of memory, that Biden had some perfectly valid defenses on certain groups of the documents. And the documents with respect to which he spoke to the biographer, as I recall, were one of the groups of documents where he thought that Biden had a good defense, even apart from his lack of memory.
Right. So the media is really not correctly describing the grounds on which Herr is basing his opinion. Right. They're just on both sides, left and right. Mainstream media is doing a terrible job too. Of really saying what it is that Herr was saying, actually, about why this group is out, why this group is problematic, but then the mens rea problem arises. But focusing on the mens rea, can you speak to this as a former long-term prosecutor? I hear comments like, well, nobody else gets off for those reasons, or the fact that he, is an old man, enfeebled, shouldn't enter into it. But that's not actually the way it works, right?
Well, of course not. There's a level, and I sort of skip past a lot of the academic exercise about this set of documents in this time period.
Right.
I mean, it's practical reality. If it's my case, I look at it and say, okay, look, maybe I can indict him in December of 2024, and maybe I get to trial in the summer of 2026. He's already in early stage dementia. Why am I going to waste all that time and effort when I know by the time we get to the summer of 2026 he's going to be incompetent? Now, I think Herr was not willing to put that in writing because
not that baldly, right?
Yeah, because of the political implications of making that judgment about Joe Biden now in a written report to the Attorney General that's going to be made public. But behind closed doors, that is going to be a primary consideration on exercise of prosecutorial discretion. Yes, we could prove the elements of this case in a vacuum. We don't try cases in a vacuum. We have to try cases with the defendant sitting there, and his lawyer, is going to tell the judge, my client cannot meaningfully assist me in the preparation of defense because he doesn't remember the events. So I can't put him on the stand to testify on his own behalf because it'll look like he's lying. So, that is sort of foundational incompetence to stand trial. And if her is looking at this now and projecting ahead, understanding the science, the medicine, that his condition will not improve, it will only get worse, that's why you don't go forward. You write your report to write the report. That's for public record. That's for public consumption. That's for the Attorney General. But behind closed doors, you say, we're going to be wasting a lot of time for a trial that's never going to happen.
Ship, I agree with you, and I think reading between the lines, that's exactly what he was saying. That I interviewed him, and he has no memory of any of this, and he's not going to be, even today, cannot assist his counsel because he doesn't remember any of this and can't. And he's not lying about that. That between the lines, that's effectively what he said. But he also said that he was sufficiently competent back in 2017 to know that he had documents he was not supposed to have.
Right, exactly. And so, in theory, he could be prosecuted for that, at least under 793 on the willful retention. But I don't think on the taking or the disclosing. I think Her's right about that. They can't prove all the elements they need for that.
Well, let
I
me
was just
just
gonna.
make this point. In 2017, he told the biographer, I know I've got classified documents. That was basically 7 years ago.
Right.
Can we prove that any time within the last 5 years he still realized he had those documents?
Right. But we've got 10 years to prove it. So 793 is a 10-year statute. So 10 years from then is 2027, right? If Trump wins the election, maybe you could prosecute him. But if Biden wins the election again, he can't be indicted as the sitting president. And this raises an issue that I always want to point out to people. No court has ever said, because they've never had to, whether being the president means you can't be prosecuted. It's generally accepted by the legal community because the Office of Legal Counsel in the White House has said that the sitting president cannot be indicted. But no one has ever gone this step farther to say, okay, but does that mean that the statute of limitations is told while that person is serving, and you're not losing the time while they're president, and you can kind of ignore that passage of time after they get out of office? So there's no answer to that question. So even assuming you could do the statute of limitations is told while he's president, now you're talking about how old will he be if he gets reelected and then serves his full term? He'll be almost 90 by the time you could prosecute him. Nobody's going to do that.
Which is why Her's call here was an easy one.
Yeah.
But it doesn't answer. Does it answer the selective prosecution question?
Right. And that's where it's very interesting that it really plays into that issue for Trump more than it does for Biden as a practical matter. Aaron, I saw you. You wanted to chime in there. What were you going to say?
No, I was just going to say that this sort of evaluation was an evaluation in every case in the
Every
IRS,
case. Yes. Right.
and
Of
in
course.
fact, there was a period in time where we actually had to write it in our reports and cover these factors. And if they were not satisfactorily covered, the case never got referred over to SHIP's office ever. And then I personally had cases where we just stopped investigating or decided not to prosecute on these factors. So it is not at all unusual.
Right. And the reason people don't know about it is because those cases don't get brought, right? Like I handled dozens of mishandling of classified information cases as criminal cases, and dozens of them where the criminal case was already finished and I was dealing with the security clearance issue. Lots and lots of people don't get prosecuted. Plenty of people do, but lots of people don't because it depends on all of the facts. So,
But let me add, if her thought that Joe Biden was competent to stand trial based on his other findings, he would have simply sat on this for another 8 months and waited for the election. Because if Biden loses, then he can be prosecuted.
right, next
The
year.
fact that he acted now and didn't even wait for the election means he doesn't think he can stand trial.
Right. Now or later. Right.
I don't think he could have sat on the report that long, Bill. I'm sorry. I think the political pressure was too great for him to come out before that.
I don't know how long he's been working on this. I
Right.
guess maybe a year. I guess it hasn't been that long.
Yeah, I think he could have held out until the election, honestly, because no one was like clamoring for it. Although, as the election drew nearer, there would be clamor, right? So,
Well, but look, the problem here is this. The problem is that Hur is a straight shooter and a man of integrity.
right.
That's why Merrick Garland, Merrick Garland has his faults as Attorney General, but he played it straight here. He went for somebody as the
Special prosecutor.
as the special prosecutor who had impeccable credentials and who was a Republican, not a Democrat. And he got her, and her has done the sort of professional job he was supposed to. And part of that was that he couldn't sit on it. So I just don't read. I agree with a lot of the points you've made up until now, and your point about that whether he thinks Biden's competent to stand trial is a fascinating point, on which you may be right. But I don't think that you can read anything into the timing other than the fact that this is a guy who was playing it straight down the middle.
Well, that may be, but Her's response to the members of Congress when they were like, well, that was inappropriate for you to comment on. And he was like, oh, no, back the fucking truck up. This is exactly what I should have commented on in terms of his competence. He came out swinging on that stronger than anything else, I thought. And that may also be a tell that that's the real reason. He thinks this guy can't be tried.
Which is itself a stunning.
Yes. Yes, absolutely. It's jaw
Yeah,
dropping.
and
Yeah.
that's why. But that's why he couldn't write it.
Right.
That's why he could not come out and write that, because that would have set out a firestorm.
And then Biden screwed it up by getting all pissy with Peter Doocy and screaming about how dare they ask me about my son. That's what forced them into releasing the transcript.
Right, and that showed that again that Hur was exactly correct, and the Biden story about how the death of his son came up was completely erroneous.
Right. Irrelevant. The other thing is, these leftists are all like, he shouldn't have commented on that. That's not an appropriate thing. And I'm like, that's the reason he didn't say the president should be indicted. Would you rather have him say that, oh, he's perfectly competent, therefore we should indict him? Like, that was the reason that Hur decided not to recommend charges. It doesn't make any sense from the left.
One thing I did notice in the report that I didn't really agree with, but I think was that the deletion of the tapes. I would have been arguing in Chip's office for prosecution of that guy. I think I would have
Yeah,
lost.
I think any agent would have. I thought the same
Yeah,
thing too. I'm like, come on, fucking please. You knew there was an investigation, but you didn't think they'd be interested in hearing from you, but you also decided to delete your audio tapes. Okay. Now, I think he saved himself because he gave them transcripts, right?
yes, and the interview they interviewed him, and he said he didn't delete them because he didn't want investigators to see them. Sure, he didn't. I mean, come on.
Yeah, right, please. Yeah. No, I wasn't believing that either. But that could have gone, as prosecutors are, that could have gone either way, probably.
I don't think I would have won that argument. I have never won an obstruction of justice argument ever.
What Aaron's talking about, you guys, is when you're an agent, they go in and they pitch cases to the prosecutors. And it's funny because I've been on both sides of this coin. Now, when I was an agent, I was not a criminal agent, but I was an agent. And so I have a lot of sympathy for agents. And so the agents will say, oh, these prosecutors, they don't want to prosecute anything. They're afraid to try these cases. They won't go after the bad guys, right? And on the flip side of that, the prosecutors say, oh my God, these agents don't have this buttoned up. They just always going to go after everyone. There's just not enough proof. We're never going to be able to put that in front of a jury. A judge isn't going to let us, do this, that, and the other thing. And so it's just like a perennial argument between the two sides.
It's
Hey,
very
hey
tough.
Aaron, let me ask you a question, and I'll give you the details of this at another time. But I'll just ask you just this specific question. Did you ever prevail upon a prosecutor to indict for obstruction of justice just because you didn't find something when you searched for it? So the defendant must have discarded it?
No, I never prevailed on a prosecutor for obstruction of justice ever, not by itself. And we had some pretty doozies. I remember one interview where he was operating a call center for a crime, and we went and talked to him, and he looked in the yard and saw golf balls and told us that the data calls were about golf balls. And we couldn't convince the prosecutor to prosecute on that.
Right.
But what I found is with those cases, what we'd have to do is we'd have to beg the prosecutor to bring these people in front of the grand jury, because when we interviewed them and came back, they would just see the 302 or the MOI, and they wouldn't be so impressed. But if they put them in front of the grand jury and those people lied to them,
Yeah.
they were
Then they would
suddenly
be upset.
incensed.
Yeah.
Well, it's a shame you never got to work with any of these J6 prosecutors, because merely not finding something during a search was grounds to indict the defendant for improperly or illegally discarding the item that you didn't find.
Well, you're supposed to hold on to all the evidence that convicts you, so that when they show up at your house, you can hand it over to them. All right. So, Steve, what was your comment going to be? Oh no, he's moved on. So, okay. Well, so the bottom line is, to me, on Her's report and his testimony, he seems like a good example of a lot of the prosecutors that I used to deal with, not the ones I was dealing with at the end of my career, these young pups who I thought were ridiculous, most of them, but an older version of a DOJ career prosecutor who he's just like, look, these are the chips and they're going to fall or not fall or whatever, but this is what the answer is. And his report reads that way too. And I wasn't surprised that ultimately they concluded they couldn't prosecute him, which is not the same thing as saying he didn't improperly take classified information or hold it after he left office and then didn't give it back when he realized he had it. He's sitting there talking to his ghostwriter, right? Instead of saying, oh, well, be careful, I shouldn't be reading this to you. He probably should have said, I should be turning this information in, right? Okay. So I wasn't surprised at how Her came out. And to me, it factors into what I was saying when they first raided Mar-a-Lago, which is you don't do this to the former president, right? I'm okay with them not prosecuting Biden, but they sure as fuck should not be prosecuting Trump either on some of these same reasons, which is less about Biden as a feeble old man and more about the history of this is not really what we do to former presidents. So, King, this takes us back to your point about Judge Cannon's interest in, is this selective prosecution that we're doing this to Trump but not to Biden? So go ahead.
Not just Biden, but the
Clinton and
all
Reagan
of
and
the other
Carter.
presidents who could have been prosecuted. Yes, and this came up. I remind you, in the context of Her assessing whether the Espionage Act was too vague to clearly set out what's a crime and what's not a crime for a former president who ends up with classified documents. And I expect she may want to hear more on that selective prosecution motion.
Yeah, and Judge Cormack's opinion has given her legs on that. So I think we'll keep an eye on that. I will circulate the pleadings to you guys.
Yeah, I think that one thing that probably a distinction that needs to be drawn, though, it's not a selective prosecution claim so much as it is a dormant enforcement claim.
Yes.
In other
So
words, we've
yeah,
never
explain that.
prosecuted. So, well, it's a difference between picking one group of people to prosecute and another group of people not prosecute. That's selective prosecution. This is just, we've never used the statute against this narrow class of potential targets in the past. So why are we starting now? Why is Trump first among ex-presidents or vice presidents, even though we know others have done it? What
And
is different?
in a defense, from the defense lawyer's perspective, you're not winning that argument. I've never seen that argument work. I have made that argument and had judges say to me, "Well, so you're saying because these people they know it's against the law what they're doing, just because the government hasn't prosecuted it for 45 years doesn't mean that people don't know that that's wrong."
Right.
They don't
That
like this argument.
now, that's not to say that Judge Cannon might
Might
not
not like it. Yeah.
dismiss the espionage counts on a variety of grounds, that being one of them, while allowing the obstruction counts to remain.
Right.
And then let that go up on appeal.
Right. The biggest problem here, it seems to me, is that the allegation that Trump, once he figured out that the government was saying you shouldn't hold on to these documents, rather than just duking it out with them on that, basically said, if you believe the government's indictment, basically said, well, let's deny that we've got the documents and go stash them someplace else. Which, I mean, frankly, sounds like classic Trump, because he's a combative guy. And it's also, in comparison to Biden, there's no issue about Donald Trump being incompetent. So it's interesting. I mean, Trump's been described before, obviously, as a bull who carries around his own china shop, and that may be the case here. But you can't help but wonder. I mean, I agree with your point, Bill. What you're really talking about is prosecutorial discretion. Why do you want to take a former president of the United States, and even if you can, under the law, technically, why do you want to provoke a criminal prosecution of him because he held on to some documents that you say he shouldn't have held on to?
Well, and the answer is, and we'll close with this, I think, the answer is another literary allusion, which is that Jack Smith is Inspector Javert, right?
Exactly. Yeah.
He's the police officer in Les Miserables who's pursuing Jean Valjean to the fucking ends of the earth because he, took one loaf of bread to feed his dying sister. It's like, yeah, people who martinets, that's why we call them that, right? So it's just, prosecutorial discretion inappropriately exercised is the bottom line. But unfortunately there's not much legal remedy for that kind of problem. Can you?
Well, there's a pending motion to kick Jack Smith off this case.
Right.
Not for those grounds.
Steve's shaking his head. Nope. Right. Those motions don't usually work. But you know what? Nathan Wade got thrown off that case. The stranger things can
Unless
happen.
they can show that Jack Smith was sleeping with Joe Biden, it ain't going to happen.
No, this is the Ed Meese
theory.
Ed Meese argument, constitutional argument,
Right.
that Jack Smith is not an officer of the United States.
Right. Not properly appointed. Right.
He's not properly appointed and confirmed by the Senate. it's a really, really complicated argument that I'm not about to go into now.
Good.
But it may, but Judge Cannon's going to have to hear it.
Right. That Mises theory and also the selective prosecution. So when those I'll pull those pleadings and send them to you guys, and we can do a special discussion of just of this selective prosecution, because it looks to me like, yeah, she's going to give them a run for their money on it. And also we'll keep an eye for everyone on what happens to that case in California. The Ninth Circuit set the briefing on that. The initial brief is due in May. So that's on an expedited calendar because the judge dismissed the indictment and the government's taken an appeal, which of course normally doesn't happen. So that's on an expedited schedule. So we'll probably get a ruling from the Ninth Circuit on that sometime soon. Bill, what do you think? If the briefing's done by the end of June or by the end of May, first part of June?
Did they leave him in custody? I haven't even seen the outcome of that.
No,
Or did,
the merits brief is due May 10th, I think, or 15th.
yeah, but did they keep him? Did they keep the
Yes,
defendant in custody, or did they
I
let him
think
out on
so.
bond?
I think so. I think they kept him.
Yeah, then I'm surprised it went out that far.
When do you think we'll get an opinion from them, though? June, July?
Yeah, probably. If it's the end of May, probably late June.
Yeah. So we'll keep an eye on that and see how that goes. That may influence Judge Cannon. So, all right. Final thoughts?
None
Ship.
for me.
Okay. King? King, I love your cat on a hot tin roof story. That's hilarious.
Mendacity is the system we live in. So just keep that in mind.
Right. Right. All right. Okay, you guys. Thanks as always. And I'm sure there'll be more stuff from the fire hose this week that we can talk about. If not this week, then this weekend. So for tonight, I'll say good night.
Good night, everybody.
Night, Chip. Bye. Thanks, Aaron.